Aloha. I wanted to take a moment to tell you about this new program we have here at the Department of Public Safety's Crime Victim Compensation Commission. This is a unique collaboration between the Commission and the Hawaii Paroling Authority to provide seamless services to victims of crime. The Post-Conviction Victim Advocacy Program's mission is to provide quality direct services, resources, education, and referrals to victims of crime as the parole process begins. Our vision is to ensure that our participants feel empowered and supported as a victim throughout the parole process. The idea is to give victims a voice, to assert their rights throughout the process, and improve the services that they are receiving. My goal is to engage, empower, and instill confidence in victims to assert their rights in the post-conviction parole process. Hi, I'm Dawn Martin, and I'm one of the advocates here at the program. My role is to provide education on general victim rights during the parole process, engage in safety planning and safety wraparound services, provide victim notification updates, aid in restitution collection, and provide referral services and follow-up where needed. There are several different points that a victim can engage during the parole process. These include minimum term hearings, parole consideration hearings, reduction of minimum terms, early discharge consideration, and victim impact statements. So let's talk about what these are. A victim impact statement is a written or oral statement made as part of the judicial legal process, which allows crime victims the opportunity to speak during the sentencing of a convicted person or at subsequent parole hearings. A minimum term hearing are open to victims, designees, or surviving immediate family members. These people can provide written testimony or make verbal comments for the board to consider when rendering their decision regarding the setting of a minimum term imprisonment. When it comes to a request for reduction of minimum term imprisonment, a 60 days notice shall be given to the victim prior to the reduction of the minimum term imprisonment by the Hawaii Paroling Authority. Victims must request to be notified about developments in the inmate's case, and you can do that through our program. Victims will have the opportunity to submit written comments for the board to consider prior to rendering a decision in the application for a reduction of minimum term. During the parole consideration hearings, victims, designees, or surviving family members may attend and provide written comment to the board to consider when rendering their decision on whether or not to grant parole or not. Finally, an early discharge consideration hearing is a final release or discharge from parole prior to the scheduled supervision expiration date. The Hawaii Paroling Authority can reduce previously established minimum sentences provided that 1, the inmate submits a written request, and 2, none of the conditions outlined by the Hawaii Paroling Authority are present. We are also really excited about our post-conviction victim advocacy program podcast. It will enhance our outreach capacity to victims and the community. It'll provide a unique platform to give education on victim rights and the sharing of victim stories, resources, and training to the community, victims, and advocates. We are so excited about this piece to our project, and I hope you will join us for our release party next month. I hope this provided you with some new information about this exciting program that we have. And please reach out to me if you have any questions or you want any information. You can reach me at postconvictionadvocate@hawaii.gov, or you can reach me on phone by 808-358-8538. Thank you for taking the time to learn about our program. Aloha.